Uh, Here, our estate planning attorney, Josh Boehm, discuss securing your legacy, estate planning for business owners, farmers, and ranchers. I'd like to take a moment to introduce Mr. Josh Boehm. Josh is an attorney at Adair Law. He oversees estate planning and business planning. Josh grew up in Wisconsin and attended and graduated from Viterbo University with his undergrad before proceeding to Washburn University School of Law in Topeka as in graduating with his law degree. Josh has been in practice in Kansas and in this area for over 10 years. He is highly accomplished and has a lot of knowledge and skills in a variety of legal disciplines, including estate planning, business formation, real estate. And today, Josh is going to talk to you about securing your legacy. This program will focus on estate planning ideas and potential hints that can help people who are business owners, farmers, and ranchers. Josh, it's a pleasure to have you here, and thank you for hosting this event.
Thank you everyone for being here tonight. I'm actually in Kansas City right now. I'm attending the Kansas City Estate Planning Symposium. So 8 hours of estate planning, tax law, uh, real estate information today, and we'll do it again tomorrow. So like Gabriella said, appreciate the introduction. We're going to talk about essentially really closely held businesses tonight and making sure that those businesses are preserved and are passed intact and operations are able to maintain from one generation to the next. So again, estate planning is something that not a lot of people enjoy doing, gets pushed to the bottom of the list. But when you do have a business closely held or otherwise, and that includes farms, ranches, other commercial operations, manufacturing, you know, putting that off can have serious consequences for the operations and continued uh, day-to-day uh, business planning. So we're not really dealing with distributing bank accounts, personal property, things like that. When you're a business owner, you have land, equipment, livestock, intellectual property, uh, ongoing marketing, negotiations, things like that that have to have continuality to ensure a smooth transition. A hiccup, even for a week or a month, depending on the business and what you're operating, can have serious consequences. I do want to start with, before we get too far in, again, this does not make us your attorneys. This is all informational purposes. We'd be happy to speak with you in regarding your specific facts on a one-to-one basis more later on. So, uh, oops. We're going to break down some of the key estate planning tools and things to consider when you do have a business. Again, we're going to be focusing on closely held businesses. So maybe 4 or 5 members at the most, or within a family. And the idea is, again, to give you a clear roadmap and some high-level topics to make sure that you discuss with your advisors, your business partners, and things like that. And make sure that you have a clear plan uh, on what you're going for. So we're going to make sure that you understand real quick some basic estate planning tools, strategies to minimize taxes and protect assets. For this topic, we're going to be focused mostly on protecting assets. Not going to get real deep into a lot of the tax stuff. Again, this is going to mostly be about asset protection and continued operation. And the goal and objection through this is, again, a smooth transition for future generations. And that's really regardless of whether they're going to be in the operations of the business or if they're in more of a hands-off role to make sure that the business continues to operate and allows them to maintain that hands-off position. So again, real briefly, when you have a closely held business, some of the key components are you're still going to need a will, likely going to need a trust like any other estate plan. would, even if you're a cash or personal property only type estate. Uh, 3 and 4 on this screen are what we're going to spend most of the evening talking about. Uh, Operating agreements and then buy and sell options that are part of an estate plan. So those are really technically within the business itself, but they need to coordinate and work with your overall plan and what your long-term objectives are. And then again, power of attorney, healthcare directives, um, those are more traditional estate planning tools. Okay. So when you have a business or a farm, again, a lot of individuals don't necessarily think of their farming or ranching operations as a business, or think that, hey, my kids are already involved in it. It's going to be an easy transition. But you can run into a lot of hurdles unexpectedly. Um, Many of you probably have already experienced that in transition of the operation from your parents to yourself. And sometimes we learn from that, and sometimes we think it's a long ways off. But it's never too soon to start that planning. So it's important to make sure we do this planning. The first generation is always easy, or typically easy. Second generation, but the further along, the longer a business, especially some of the farming and ranching operations that we have in Kansas here, that may be 100 years old and multiple generations, it continues to get harder and harder as things maybe get diluted or you have more people involved. So we want to make sure that there's a clear timeline to help for transfer uh, of leadership, a defined financial structure for how the next generation will buy into if there's going to be a transition during the lifetime, or how they're going to inherit the business after the passing of the prior generation or ownership structure. The goal here is to prevent disputes among heirs and to keep the business or farm operational. You're making dozens or more decisions every day to ensure the smooth and continued operation of your business. And again, at the wrong time, even a small hiccup in that decision-making process can have costly consequences. We want to ensure that that transition is as seamless as possible. Again, one of the things that we talked about was buy-sell agreements. So these are a component um, of your business, and we encourage everyone to have an entity uh, own the business and the operations. The entity allows a structure outside of yourself to have control, and within that, we can have these various documents, the buy-sell agreements, the operating agreements, the bylaws, things like that we'll cover next, that outline and dictate and have statutory and legal control over decision-making process, ownership transfers, things like that. Um, Oftentimes, operations are held maybe among siblings, um, and you and your siblings may get along great. But again, as we dilute and pass this operation from one generation to the next, we're continually introducing new and different people. Cousins just inherently will not have the same relationship that you have with your siblings. Um, so we want to make sure uh, through using these agreements that we prevent ownership disputes. And again, buy-sell agreements are essentially agreements within the business that dictate the terms of the buying and selling. So it prevents disputes by creating a clear structure of how those are going to happen. Um, it maintains confidentiality of the business, because it will give uh, time periods if there's options involved of who can exercise and when you'll have to provide notice of intent to exercise, once you're going to exercise a purchase, how long you have to provide funds and close, who comes next in line if the option is not exercised, things like that. Who controls or operates the business, maybe while that ownership share is going through the transition process. It can also set fair price and terms. It could be by a formula. It could, be per share with escalators. It could be based on an appraisal process that's predetermined. There's any number of ways that we can come up with, again, structures or formulas so that the price is essentially uh, predetermined, and take a lot of the negotiating out when we're going through this transition period. Emotions can be high. There can be questions over leadership, things like that. And these agreements protect the owners and their families. So, and it's not just about the next generation necessarily. It also provides protection for the surviving owners. If you have a multi-member entity or a corporation where uh, a number of, small group of people, again, maybe four, five, six people or less own shares of that stock, it protects them so that their decision-making authority is not undermined or diluted in any way. And you are not introducing necessarily people who um, don't have the same values or uh, intentions with the business as was originally set up for. Along those same lines, we can restrict unwanted ownership. Um, these agreements can also be useful not just at the time of death, but they can be useful and come into play at various other times when an owner is living still. If an owner experiences a personal bankruptcy, a divorce, or some sort of other life event where creditors are involved, these buy-sell agreements can help ensure that the ownership is maintained within the, either the family unit or within the closely associated owners or founders who set this up. And it also allows funding of purchases or protections through perhaps life insurance that can be purchased. Key man policies is a term often used to ensure that these, again, perhaps founders or other key members of the ownership structure, uh, that their interests can be protected, that the decision-making authority stays with the people who need to maintain that to ensure operations while still protecting their families and ensuring that they get a buyout. Operating agreements and bylaws. Um, so these are the key formational documents involved in an LLC or corporation. Again, depending on the type of entity that you have. And they're useful for clarifying the roles of the various members, directors, owners, uh, ensuring that there's a written path and instruction. Uh, a lot of times businesses get started and you're bootstrapping things, multiple members or founders coming together, and the paperwork kind of gets forgotten. Everyone gets along, things are going well. Um, no one's anticipating this falling apart. No one's anticipating an untimely death or illness. It's important when the times are good, when everyone is operating, together and working together, that we clarify roles and that we reduce these things to writing. These things are also important for maintaining the liability protections that these entities provide you. We incorporate and form limited liability companies for that very purpose, to limit liability. But if we don't observe these formalities and document these things, those liability protections oftentimes don't exist. The operating agreement can also work to outline some of the same things that the buy-sell agreements do. Okay, outlining succession procedures, how votes will happen, percentages of ownership that need to vote on different matters. Are certain things going to require a simple majority? Will others require two-thirds, three-quarters? What are going to be the various thresholds for the different decision-making processes and items that happen and occur within a business? The next two kind of go together again, controlling ownership transfers and integrating the buy-sell agreements. Uh, Buy-sell agreements can be adopted as a second document that's included by reference through the operating agreement or the bylaws, or the actual buy-sell terms can be worked into those agreements themselves. A lot of times it depends on the type of entity, how closely it's held, and how complicated those terms are, along with their likelihood of changing. So those buy-sell agreements, whether incorporated into the document itself or adopted separately, again, can work to control ownership transfers. Ownership transfers are also controlled through the dissolution process that we outline in operating agreements. You know, much like your personal life or your marriage, no one wants to think of a divorce or any sort of, parting of friendship or goodwill. Uh, but that's really what the dissolution of business is. I mean, you're in a business, you have a small number of founders, co-owners, members, or partners in this entity. And if there's a breakdown in communication or fundamental disagreement on the direction of the company and where this is going to go, someone needs to be able to make that call and decide what's going to happen. Someone may want out. There may not be a way to resolve that. So we can include provisions in there that dictate how that dissolution process works. Um, Again, at some point, it may trigger terms of a buy-sell agreement. There can be standoff provisions that dictate who makes the initial offer. Is there an ability to match the offer? Who has the right to match? What's the time window for matching? Uh, when those options expire? What happens if the options aren't exercised? Um, so, for example, you have four partners. Partner number four wants out of the business. There can be terms that dictate that partners four shares or interest percentage is offered to the other three. And again, it could be by a set formula. It could be at an appraisal at the then current value. Uh, and it's going to outline perhaps who it gets offered to first, the percentage that each of the others is able to buy at any given time, and how long they have to exercise that before partner four can sell it outside of the current ownership structure. Uh, we also want to make sure that the various owners, uh, that their interests that they hold, again, whether it's stock, maybe they're in part of a partnership, a member in an LLC, that aligns with their overall estate plan, and that the terms of those agreements or the ownership control don't conflict with how they intend to transfer that interest. And if they're planning on well, I want this business to transition to the next generation. I want my third of this business to go to this beneficiary or heir. You know, is that actually allowed under the operating agreement of the business? Or is that beneficiary going to take it, but they don't have voting rights? Um, and they strictly have a right to income from the business. And finally, prevent court intervention. We can never prevent all court intervention. People are going to have conflicts. People are going to fight. Um, but in the absence of no plan, then the court is going to be forced to construe uh, terms and sale agreements pursuant to state law based on the structure of the entity. Again, whether it's an LLC, a partnership, a corporation, and then work off of prior tax returns, perhaps, or some other uh, accounting or record keeping mechanism to determine ownership interest, shares, transfers, intestate succession in the event of a death, who takes an owner's interest. And again, generally speaking, the tighter we control, the more communication there's been, and that these things are outlined in the written documents, the less likely it is uh, that someone is going to contest a transfer, uh, how an option is exercised, things like that. So now you understand a little bit some of the main tools that are used in transferring the business or farm interest. We're going to talk a little bit now about how those can be done and the considerations to that should be made in creating uh, what those look like and the terms of those different tools. So really, you can sell again to a family member or a third party, uh, again, depending on the type of entity and what the hope and plan is for the future. What is the legacy of this company? Um, Again, is this something that has been maintained within the family for multiple generations? Is this something that new that was founded amongst friends or maybe within family? We can do that sale again either during life or at the time of passing of a member. We can also gift or gradually transfer interest, not through a sale um, during a party's lifetime or again at death. So what is the timing of that and how slowly do we move that interest or how quickly do we move it from one generation to the next or one set of owners to the successors? And again, typically we're going to use a buy-sell agreement um, to accomplish that. So for this slide, we labeled this and talked about this being a um, family meeting. But really, when we're talking about family, these are the key stakeholders. So the current ownership structure, again, in a farming or ranching setting, that's likely going to be family. Uh, but in a different business structure, again, it could be a closely held group of owners. Um, but we want to make sure that, again, before documents or drafts or things like that really start flowing around, um, everyone's on the same page for what is the legacy, what is the future, what is the roadmap of this business? Can we get on the same page there um, and reduce that conflict, talk it through in an informal setting, uh, and address some of these things early on. Part of doing this is to make sure that we minimize taxes and protect the assets. So there's only so much that can be done from a tax protection point of view. Um, but again, we want to make sure that the assets are protected from other creditors, from dilution of ownership interest, voting rights, control, things like that. So we want to make sure that we have clear timelines, defined structures, and everything is put in place. Uh, so Kansas does not have an estate tax or an inheritance tax at this point. That strictly exists at the federal level. This was one of the big topics today at continuing ed and the seminars. Uh, Tax Cut and Jobs Act that was passed during the first Trump administration significantly raised the federal estate tax. Currently, it's sitting right around $14 million per individual. So for a married couple, $28 million is the full exemption amount. That's the amount of property, cash, assets, ownership interest that can be transferred from one generation to the next, uh, either through passing or through gifts, before triggering the federal estate tax. That is set to sunset at the end of this year. Uh, how that's extended, for how long it's extended, at the amount that it's extended is really up in the air and unknown. Um, what we can say is that this $14 million limit is as high as it's historically been. It's significantly higher than what it was 15 years ago, 20 years ago, 30 years ago. Um, and if that's a number that comes into play in your estate planning, then it's definitely worth making sure and looking over the last, you know, part of the year here that you've taken full advantage of that or are prepared to take full advantage of that before the end of the year in the event that is not extended or doesn't look like it's going to be extended. So if you have property in other states or reside in other states or maybe moving to other states, it is important to know what that state may have in the way of an estate or inheritance tax. Again, Kansas does not have one at the state level. So gifting is an important part of that. There's annual exclusions that can be exercised, but there is lifetime exemptions, which is that estate tax limit. Um, and so that's another way. Again, if you start the further out you start planning, the more tools, the more options you're going to have at your disposal to make these transitions from one generation or one ownership group to another. Um, so next we talk about conservation, um, and this is designed specifically from the point of view of conservation easements. But anytime that real estate is involved, and again, this is not limited just to farmers and ranchers. It can be any sort of development, commercial developments, residential, um, any sort of real estate, heavy business entity can utilize these. So it could be, again, conservation easements. It could be covenants. So these are restrictions. Most people are familiar with covenants in the point of view of maybe like an HOA or something like that. Um, and again, development or land use, we can adopt those outside of the HOA and restrict what the use of that land is. Um, that can disincentivize uh, potentially different buyers who may have a different land use in mind and devalue the land, making it easier for the current operation and the current owners to maintain it. Conservation easements are along those lines, but they're a specific tool in Kansas and most other states. that are adopted in part of state statute that outline the use of different property that is placed within these uh, special easements, what can and can't be built there. Again, so oftentimes, if you're trying to maintain an agricultural use, uh, we can use conservation easements over portions of the property uh, to prevent any sort of development. And by limiting the development on the various individual portions, you can essentially um, lock up the balance of it or limit its usefulness for other non-agricultural purposes, um, making it perhaps easier to uh, maintain that family farm or that ranch, um, keeping the tax burden down, things like that. We can ensure, again, that the use of the property, particularly as urban sprawl occurs, make sure that farmland is maintained in an agricultural state, or maybe land that is not in an agricultural state is placed into that to reduce its holding value and the tax burden. One of the big things in any estate plan, uh, whether a business is involved or not, when we're looking at the preservation of assets and protecting it, is what is the tax drag on it? If it's something that's income producing, how do we reduce that income tax? If it's real estate or property, how do we protect it from a property tax point of view and minimize the cash drag on the cash assets that an estate may have? Um, Again, particularly in like a farming or ranching situation where the estate is going to be uh, likely property heavy. There may not be a lot of free cash. All of the value is in the real estate, or a bulk of the value is in the real estate or in the equipment. Um, if you have a manufacturing facility, it may be, a lot of the value could be in expensive specialized equipment, or maybe equipment that's not made anymore or is difficult to procure in the event that it had to be sold off or liquidated. And then LLCs, and again, this isn't just LLCs, but it's any sort of corporate entity. Again, LLCs, partnerships, corporations, we want to create a separate structure um, with legally outlined uh, documents, provisions, and everything again reduced in writing. Uh, and this protects you not only from the transfer point of view, but again, we touched briefly from the liability point of view. You can also structure it differently depending on the type of business. Uh, do you want this tax at your individual level, corporate level? Are you going to receive payments as a W-2 employee? How is that money going to transfer out of the business into the individual owners? It can also be used to slowly transfer interest. Maybe we're moving a few percentage points of interest each year or every few years from one generation to the next. It allows an easily documented manner to do that, either through, again, with an LLC with a percentage of ownership or through shares of stock in a corporate setup. Again, so these are common estate planning mistakes, but these are things that are compounded when dealing with a business entity. So failing to plan ahead, again, high risks of procrastination here. The worst time to create an estate plan is when the crisis occurs, but that's really when a lot of people start to figure it out. Owner has a stroke, suffers a car accident, something like that, and now we're in crisis mode. There's maybe been discussions, maybe those family meetings have happened, and everyone knows, well, this is what was supposed to happen. But if it's not reduced in writing, there's no guarantee that one, it will happen, or two, that it even can. So again, when you're running a business, it's not just, maybe what the owners want to do, or maybe what the heirs or beneficiaries want to do. It's, you know, what are your obligations to your lenders? Do you have other creditors? What are the tax obligations of the business? Some of those things are going to dictate what you're able to do when you have those contractual obligations to other third parties. Estate plans are not set and forget. Um, we talked a little bit about the impending sunset of the estate tax cap that exists right now in federal law. But it's not just changes in law, birth, deaths, marriages, divorces, all of those things shift in business operations. Maybe you're transitioning from, or the business is undergoing a shift in goals, objectives, what it produces. All of those things are going to dictate or potentially dictate changes or at least require an evaluation of the estate plan. And does it still meet what your goals are, what you want to leave behind, uh, and how that continues? Again, overlooking business agreements. Again, these need to align with your estate plan. Um, don't just think that whatever the agreement is, you have full control. Uh, there may be options, interest, different terms, again, for buying or selling uh, that don't allow for the type of transfer that you envisioned. So, and again, long-term care costs, planning for your medical expenses. So again, this is compounded because your business interest is an asset. And if that needs to get sold off, now that is something that you're not able to transfer to the next generation. Again, this is particularly an acute problem for farmers and ranchers. Oftentimes, the next generation is working and providing for their families off of the income from the land, whether it's crops, cattle, or some other revenue. And if that real estate is not protected, it needs to be sold to provide for your long-term care. Not only are you losing an asset, um, but you're losing an income producing asset that the livelihood and career of the next generation is based off of. Some of the things that you can do now to prevent some of these things, again, take an inventory, make sure you understand really what all is part of the business. Is the business divided up into multiple entities? One that owns the operations? Is the real estate separate? Maybe the equipment is separate as well. You could have multiple entities all really part of the same business operation. Um, you could have the intellectual property. There could be patents or trademarks that are owned separately and licensed back to a different entity. And not only where are those, but how are they tied together from one company to the next? Is the ownership of one part of it different from the other? And then you need to meet with an estate planning and business attorney. Make sure that, okay, we've outlined, we know what we want to do. We've had the family meeting. We've met with our partners. These are what our concerns are. Um, do we have these things adequately protected in the documents that exist? And then once you have the plans, have they been communicated? Does everyone understand where they are? Have we done the documents? Have we done the drafting? Have they been signed? oftentimes we'll see great plans, but that's where they left. They stayed as a plan. They were never formally executed. They weren't signed by everyone. They didn't get completed. As part of this, again, we've talked about this from an attorney point of view, but really, we're just one part of this. You need to make sure that you talk to your tax preparer who is familiar with your books, your income, things like that. And then you need uh, someone to help you from a planning and strategy point of view. And that may be your tax preparer. That may be something that's within their expertise. Um, Depending on what the tax concerns are, that could be your estate planning attorney. Also, financial planners, depending on what your other assets are. And again, what you're transitioning from one generation to the next is a whole package. Uh, Lenders, again, you have other creditors of this business. What are they going to permit? Are parts of those loans personally guaranteed? Um, are they 100% with the business? Are those lines of credit going to continue to be in place or available? Is there going to need to be refinancing done? Making sure that all those things are in place. And then again, once you have a plan that's been developed with your partners, your family, your other advisors, getting with an attorney to ensure that all the various documents are done and they all comply with Kansas law. Again, the last thing we really want is all this hard work to be undone because either something didn't get done or it wasn't done correctly. So I'm going to wrap up here pretty quick, allow everyone to ask some questions if you have any. Coming up, we do have 3 more webinars in this series. So in the end of June, we're going to talk about estate planning for blended families. Again, maybe for second marriages. Um, August 26th, future-proofing your assets. So again, estate planning, like we talked about, cannot happen at too early of an age. Do not put this off uh, to your final years or till some sort of health crisis triggers it. And then October 21st, rather than from a planning point of view, we'll talk about the final part of the estate plan, carrying it out. What is probate? Division of assets. What do we do after someone has passed? I'm just going to see, does anyone have any questions regarding anything that we covered related to estate planning, closely held businesses, anything like that?
Josh, I think
Yeah.
the most important question I think now is how easy is it to get started with an attorney like you? If somebody does have questions that they don't feel comfortable asking
Yeah.
in this type of setting, how would we go about reaching out to you and what is the steps to, I mean, are we allowed to have, do we have a first meeting and how does that normally go?
Yeah. So what we'll do, and I can speak to how we operate here at Adair. So you'll reach out and you'll talk to the intake staff. So Kylie and Stephanie are amazing and do a great job, but they'll get you welcomed into the firm. They'll get all your basic contact information, things like that. Make sure that we don't represent some of the other members of the company or the family members who would have a conflict. And then we get you set up with an initial meeting with myself. Prior to that, we'll likely speak with Stephanie, and she'll get some basic background on really what the questions are, depending on what the question is and what you have in place for your business already. She'll give you a list of documents that you can submit, and then I'll go through them and be prepared ahead of time to review those answer some of your initial questions, what is or isn't missing, maybe what could be changed. And then you can leave that first meeting knowing these are some priority items. Maybe everything's great and you're good to go, and you just need to come back every few years for checkup. But we can let you leave with kind of again, some objectives, things that should be done, and what the cost of those would be. Okay. I don't see any more questions, so I'd like to thank everyone for coming tonight. And I know some of you have been here for our last one back in February, so thank you for coming back and listening to more with us. And look forward to seeing some of you again in June. If you have any questions, feel free to reach out to us. Again, contact information is on this last slide here. Thank
Absolutely.
you.
And I apologize to everyone. I couldn't get my microphone to turn back on, so my apologies. Thank you to everyone for joining us. We do appreciate it.
Okay. Thank you. Bye.